Thank you for your attendance. I think we might get underway. The attendance is not great, but that's not a concern so much because the session is being recorded. So if anything is unclear and you want to listen to the recording for that clarification subsequently, or if you have friends or flatmates or whatever who couldn't be here but would like access to the information about next year's courses, then assure them that this will be online and certainly well before enrolments open on the 1st of November. So I'm Stephen Penk, one of the Associate Deans. I have the honour of facilitating this gathering for the next two and a half hours. It's something that we do annually to advise you about the elective courses that will be offered next year, and also before we get into the specific courses, we need to talk a bit about enrolment processes, particularly as this time around there are some changes. So there's a variety of materials available here on the table at the front, and again, for other people that couldn't be here, feel free to take copies for them. This scenario for next year is about 98% settled, so there are still a few outstanding issues to do with assessment of some particular elective courses that we need to pin down. But otherwise, we've given you up-to-date materials as far as possible, reflecting the situation as of this morning. I say it's incomplete because the law school is going through at the moment through an academic appointment process. There will be some new academic staff joining us next year following that process. It's possible that one or two or more elective courses would be added, more likely in the second semester than in the first next year. So if somebody's currently teaching, let's say, in a Northern Hemisphere law school, and we offer them a position and they accept it, and then they give their usual period of notice of 6 months, we may not see them until May, perhaps next year, and it may be that they can offer additional elective course or courses in the second semester. Before we get on to the specific courses, you'll see from the agenda that there are some generic things to cover. And in addition to what's printed there are a couple of things that I want to add. One is specifically to do with enrolment processes, which we'll talk about in a moment. And the other is to do with the availability of master's courses to Part 4 students. So it's possible to include one or two master's courses within your LLB or LLB honours degree as electives in Part 4. We'll have some detail about that later in the session. All right, just an overview of the degree structure. It's not very clear there. That's from the law undergraduate prospectus. At least some of the course codes aren't clear, but the blue indicates the core courses within the LLB degree, and the elective courses are the red or orange ones that come in parts 3 and 4. And students sometimes are not sure how many points they need in elective courses, and they sometimes get confused about the status of legal ethics and whether or not it's elective. It is elective within the LLB, but it's a requirement, of course, for admission to the bar. So the starting point in working out how many points you need in parts 3 and 4 is that across parts 2, 3 and 4 of the degree, the law courses need to total 360 points. Now, most of you will have completed part 2 inclusive of Law 298. Law 298 carries 10 points, so that makes Part 2 130 points, as you can see out on the right of the diagram. Part 3 is 120 points, and if you have done Law 298, then you need only 110 points in Part 4 to make that overall total of 360. If you're one of those students who did the old Law 299 up to 2015, before we introduced Law 298, it had 0 points, and for you, Part 2 will have consisted of 120 points only, and therefore Part 4 will need to be 120 points to make up that overall total of 360. So 360 is the starting point. Deduct the blue, and the rest are electives. Make sense? If any of this is unclear, there will undoubtedly be opportunities during the session where we may be waiting for somebody to come and present about their course, where we can revisit any of these generic issues if you wish. All right, students who are doing honours, on top of all of this, do a further 60 points. So there's a 20-point honours seminar, which is normally taken in Part 3, but it could be in Part 4. And then there's a 40-point dissertation, which is a piece of individual research resulting in about 15,000 word paper that is submitted, which is weighted as 40 points. And that comes in the semester following the completion of Part 4. So the regulations say if you're an honours student, your dissertation must be submitted not later than the end of the semester in which you completed the Part 4 requirements for the LLB degree. Eligibility for honours: students who have completed Part 2 can be invited to transfer to the honours program, and they will need, at that stage, an overall weighted average of 75%. So we're looking at the marks rather than the grades or the grade points, and we are taking into account the results that you got, the marks that you got for Law and Society, and Legal Method, and Criminal, and Public, and Torts, and Contract, and Law 298, all weighted as 15, 30 or 10 points respectively. And as long as it comes overall to 75.0 or higher, then you'll be invited to transfer to the honours program. Invitations for those who are completing Part 2 this year and who meet that requirement will be sent out in the middle of December, and you have until the middle of January to accept the offer to transfer to honours if you wish, and to indicate what your preferred honours seminar course would be for next year. Once we've had all those responses, some honours seminar courses will be oversubscribed, and so we will have to make a selection, and some students may get their second or even their third choice of honours seminar, and all of that you would know by about the 20th of January next year, in time if necessary to amend the courses that you've enrolled in the meantime. All right, let's talk about enrolment processes because there are some major changes. So firstly, if you are already beyond Part 2, you're in Part 3, then you're in the LLB 3 group, which means Part 3 and 4 students, and from the 1st of November onwards, you can enrol in your courses for next year, subject just to any prerequisite considerations. Now, we don't know exactly when on the 1st of November enrolments will open, but the indications are that it will not be at midnight, and it's more likely to be at breakfast time than at 2 or 3 in the morning. And what the university is concerned about is that it has allowed students to start enrolling from midnight, and about 80% of law students are enrolled within a few hours of that midnight opening. But the system sometimes can't cope, and there's no IT support available in the middle of the night. And so I think the university is going to open enrolments probably around 5, 6, 7 a.m. But so how early is breakfast? But the message is don't stay up all night on the 31st of October. You might have a frustrating experience. If we know with any certainty when the enrolments will open, what time precisely, we'll let you know. Okay, so if you are currently in Part 2, and this year we'll be completing Part 2, so next year you're a prospective, will be a Part 3 student. In the past, it has not been possible to enrol in any Part 3 courses until mid-December. It hasn't been possible to enrol from the 1st of November because the university has required us to check that you have in fact completed all your Part 2 requirements, which we can only do when the Part 2 grades are finalised in December, and then move you to the Law 3 group, and thereafter you can enrol. And so that has meant that the students moving from Part 2 to Part 3 have been at a disadvantage in terms of securing their preferred streams in land, equity, in elective courses and so on. The process has now changed. If you are enrolled in courses this year that will complete Part 2, either you're doing the whole of Part 2 or you're doing the second half of it because you did the first half last year, we will assume that you will pass this year's courses, and you can provisionally enrol for Part 3 from the 1st of November, so you can have equal access to your preferred streams of the compulsory courses and so on. If indeed you fail something and you haven't completed Part 2, then we will have to intervene and perhaps disenroll you when we discover that sometime in December. But that will affect very few students because the pass rates in Part 2 are very high. If you are currently, say, doing the second half of Part 2, you're completing Part 2, you're doing the first half of Part 2 now. So next year you need to complete Part 2 and you simultaneously want to make a start on Part 3. All that's been possible in the past has been on the 1st of November to enrol in your outstanding Part 2 courses. So let's say you're doing at the moment Law 298, Crimes in Public. Next year you need to do Torts and Contract. You can enrol in Torts and Contract, and nothing else has been possible until mid-January. Again, that has changed. And so you will be able to enrol from the 1st of November in the outstanding Torts and Contract and in elective courses to make a start on Part 3 concurrently with your completion of Part 2. Is that clear? Anybody not follow that? Well, good. Thank you. You have a sheet about enrolment processes amongst those handouts. So the thing that I have skipped, the first item on the list other than the statement that enrolment's open on the 1st of November, is in respect of prerequisites for elective courses. Up until now, virtually every elective course has had as its prerequisites the whole of Part 2. Now therefore, students who are completing Part 2 and want to start Part 3 haven't been able to do anything for Part 3 because they haven't completed Part 2, unless we gave them a concession, and typically between 50 and 60 students would apply for concessions each year. We have reduced the prerequisites for the Part 3 elective courses. And so now the whole of Part 2 as a prerequisite is atypical, it's unusual. The prerequisites for elective courses will now be a subset of the Part 2 courses, and as long as you have passed those, or we anticipate that you will pass them this year, then you can go ahead and enrol in elective courses to make a start on Part 3 at the same time. So you have some information there about the prerequisites for elective courses, the revised list. So just to take my own privacy law as an example, its only prerequisites are public law and torts. So anybody who this year will have passed public law and torts will be eligible to do privacy, maybe while they're doing crimes and contract in 2018. And so it is with the other electives as well. All right, I think we've briefly covered everything else that's on that page headed enrolment and electives for 2018. Law 498 and Law 499 caused some confusion, so let's just talk briefly about those. Prior to this year, the usual requirement at the end of the degree was that students, and this is reflected in the Law 499 enrolments, would have participated in a moot above Part 2, so either the faculty moot in Part 3 or one of the maybe competitive or subject-related moots, so long as it is beyond Part 2, and have written 5 pieces of writing of a certain length, 1,500 or more words. So Law 499 has been about breadth of writing and participation in one moot. And students enrol in Law 499 at the end of their degree. Now that doesn't mean that they can only satisfy the requirements in their last semester. They satisfy them across Parts 3 and 4, but the enrolment comes right at the end, and that's just our opportunity to gather up the bits and pieces that you've done and make sure all the boxes are ticked. That has been replaced by Law 498, and here the emphasis is not on a number of written assignments, but one sustained piece of writing of at least 4,000 words. Plus a moot beyond Part 2. So now there are only 2 ticks required in 2 boxes. One is the moot box and the other is a piece of sustained writing of 4,000 or more words. Completed somewhere in the course of your law studies. Law 498, replacing Law 499, is required of most of you. Law 499 continues to be available only for students who were already in Part 3 before this year. And it's being phased out at the end of next year, so it's just retained in a transitional way for students who expected to complete 499. Most of you will be enrolling in Law 498. Again, you enroll in it right at the end, but you may complete your moot and your 4,000 word or more piece of writing at any stage during Parts 3 and 4. So it's not related, the completion, satisfaction of those requirements isn't linked to the actual enrolment for Law 498. Does that make sense? Nods and no shakes of the head. Okay, well, we'll assume that you've understood that. Thank you. The 4,000 or more word piece of sustained writing, single piece of writing, can be satisfied in a number of ways. So again, just to take my own elective course as an example, you will see for privacy law that there are 2 ways in which students can be assessed. Everybody has to complete a 1,000-word research. 1,000-word essay, which contributes 20% of the final grade. For the other 80%, it can be either a 2-hour exam or a research paper in lieu of that exam on some privacy topic. And that research paper has been deliberately styled or fashioned as a 4,000-word piece so that it satisfies the requirements for Law 498. So by doing a research paper in lieu of exam, you're basically killing 2 birds, as it were, with the one stone, satisfying the Law 498 requirement and avoiding an exam by substituting for it a piece of sustained writing in the elective. And papers in lieu of exam are available in most elective courses. And even where on this chart that you've got, the spreadsheet that you've got, which shows the assessment, Even though it may not say a paper in lieu of exam, it's always open to negotiation with the teacher of the elective course to be able to substitute a research paper in lieu of the exam that you otherwise would be sitting. So papers in lieu, as long as they're 4,000 or more words, satisfy the Law 498 requirement. A supervised research paper of 10,000 words, that's a 15-point elective, which allows you to write on any area of law whatsoever, so long as somebody on the staff is prepared to supervise it. That clearly will satisfy the requirement for Law 498 of 4,000 or more words in a single piece of writing. Every honours seminar paper of 10,000 words will satisfy that requirement. Every honours dissertation of 15,000 words obviously satisfies the requirement. But for those of you that are not honours students, just remember there is a requirement that somewhere along the line in part 3 or 4 you need to have written a single piece of at least 4,000 words, and a paper in lieu of exam or a supervised research paper may be the way to satisfy that requirement. And the last thing just to mention briefly at this stage, but we'll give you some detail about it later, is what I mentioned at the start, and that is some of our 30 or so master's courses that we offer each year are available also to undergraduate students who are in part 4. So if you look at the range of master's courses for next year, and there is something there that is attractive to you, it may be that it's one of those courses where we welcome undergraduate students and it can be taken in substitution of a one or more undergraduate electives, and the master's courses are weighted as either 30 or 15 points. An important thing to note about those master's courses is that they are assessed differently from undergraduate electives. Master's courses are assessed typically by way of research papers only, with no exams. So there are negative and positive reasons for thinking about master's courses in your LLB degree. One is that if you're not an exam-oriented student, you can do something that has no exam. You can write a research paper on some aspect of the master's course. Or it may be that the subject matter of a master's course is of particular interest to you, and you can therefore include it within your LLB in Part 4. And of course, all of those master's research papers, in lieu of exams, are of 4,000 or more words, so they're going to satisfy the Law 498 requirements as well. So that's just another option for satisfying Law 498. You've got the master's courses, you've got the honours seminars, the honours dissertations, papers in lieu of exam, or supervised research. More than one way to skin a cat or to satisfy the Law 498 requirements. All right, well, that was a bit of a speedy survey of some of the generic matters. We now come to specific elective courses for next year, and as I said, we've allowed 5 minutes for the teachers of these to present to you about their courses, and hopefully that will include details of how the courses will be assessed next year. But if we hit a dead patch in the middle of all this because we might get ahead of schedule, then we can revert to some of those generic things if you wish.
So I am teaching Women in the Law next year, Law General 422, so just here to say a few words about that. What we basically do in Women in the Law is we go through the different bodies of feminist legal theory, all of which have contributed to our understanding about how the law supports or potentially addresses aspects of gender inequality. And we start with liberal feminism, which is the reason why I'm standing here today and why some of you in the room are enrolled in a law degree. For those of you who don't realise, women in the law, women actually entering the legal profession, did so relatively recently, even though we had the first female graduate many years ago. In 1970, when our Chief Justice graduated, she graduated in a class in which there were only 4 women. She struggled to get a job, and then she actually went on the bench to practice the kind of law she aspired to practice, realising that she would never be briefed in the kinds of files that she aspired to have. So we look at liberal feminism, we look at radical feminism, cultural feminism, critical race or intersectional feminism, and postmodern feminism. And these different bodies of theory look at, well, why, if women have been entering the law school for about 30 years in equal or even greater numbers to men, why have they not progressed in the law? Why are they still only a tiny fraction of those holding positions of power? Can we actually have any political agenda organised around the concept of women when women have such other diverse intersections, and how are attributes that are associated with gender impregnated in non-human concepts like the law? We intersperse our look at theory with some practical issues. So what are some of the difficulties in combining a career in law with motherhood, issues of sexual violence against women, issues of care and contact, disputes in the context of family law, the criminalisation of parental failures to protect their kids, family violence. And basically what we're trying to do is see how theory and the lens you put on a social phenomenon actually affects your analysis and your outcomes in relation to that phenomenon, trying to make the theory kind of real. We have great guest lecturers in this course and documentaries. I'm not sure who we'll have this year yet, but last year we, for example, had Louise Nicholas, who will be familiar to you as the complainant in relation to multiple sexual violence charges against police officers in the past, who's now a victim's advocate. We had Sandra Alofi-Vai and Laverne King, who set up a firm based on tikanga Māori, only employed Māori and Pacifica women who couldn't get jobs elsewhere, and set up their own creche so they could combine motherhood with a career in law, which is always a challenge for women, and many other fantastic guest lecturers. So assessment is by way of 3 journal entries of 1,000 words each, and the best 2 are worth 30% of the final grade, and they're really inspired to encourage you to read the readings in relation to the area of theory and critically reflect on them, including relate them to your own life. And finally, a 4,000 word opinion on a topic of your choice, which is worth 70% of the course. So just a brief reflection on why you might like to take this course. It has had very positive feedback from students, so that's always a good sign. It's one of the few courses I have personally taught that students have told me they've found actually life-changing, because many young women of this generation actually haven't been exposed to feminism like some of us older women, so actually just being exposed to these ideas is pretty exciting, and many of them still have relevance for our lives. And I think also taking a course that's critical around theory really assists if you're planning on doing great lawyering. So I draw a distinction between good lawyering, where you apply the law to try and get the best possible outcome for your client, and great lawyering, which actually involves pushing the legal envelope. So that might mean creating a listening for your client that doesn't currently exist amongst a group of people that don't have life experiences that naturally lend themselves to understanding your client's life circumstances. It might mean persuading judges to be brave and overturning legal orthodoxy to achieve more just outcomes. In other words, it requires critical reasoning and a sophisticated understanding of concepts like equality, which of course are central to most of the theory in this course. Why you should not do this course? Do not take this course because it is an easy option. Postmodern feminist theory is super exciting, but it's absolutely not easy. And don't take this course because you have a timetable clash. Although I will say that one of my favourite students ever in Women in the Law was someone who took it because he had a timetable clash. So at the beginning of the course I'd gone around and asked everyone, why are you enrolled in this course? And he said he was hoping to be invisible and silent and simply survive the course, because he had bought a soccer franchise and it was the only elective course that didn't clash with his franchise. And I laughed hysterically thinking, gosh, he's witty, and then realised he was deadly earnest. So I went up to him and I said, why don't you take, privately of course, a class later, why don't you take a supervised research paper? It'd be a lot less work, and you could do it on soccer franchising or something you're really interested in. Anyway, he rejected that idea. He said he was finding the course, he'd noticed he was a bit sexist, but he was finding the course quite interesting. Anyway, and he was one of those very open-minded people who actually explored things that he was reactionary to, and he ended up transforming a lot of his thinking and being really quite excited and engaged by the course. So maybe you should take the course if you have a timetable clash. Okay, that's all I've got to say, unless anyone's got a quick question. If you do, or you come up with one later on, feel free to email me. Thank you.
Good afternoon. I'm going to teach maritime law next year. My name is Matthew Flynn. I'm currently practicing as a maritime lawyer in Auckland, and I've been doing that for far too long. I've been doing it for 28 years, and it's been fascinating. I've been all around the world as a maritime lawyer. I've been on ships in Iceland and Brazil and Portugal, and I've been in boardrooms in Germany, Greek ship owners, Hong Kong, Singapore. It's a really a very international subject. Has a huge amount of practical experience, practical application, both domestically and internationally. It's always changing, and we need young lawyers to be coming through with a good understanding of how that works, both domestically and globally. I'll just give you a very quick, I thought I'd show you some pictures because there's a lot of good stories with shipping. Lloyd's Law Reports, which is a very substantial law report, is full of shipping maritime law cases. For many, many years, the insurance industry, the Greek ship owners have funded significant litigation, particularly involving contract law. If you're really interested in contract law, this is a substantial way to get your head around and get into some really substantial contractual law issues. I'll just see if I can move that forward. Just move that forward. Here we are. Just give you a quick definition. Maritime law is a functional term used for describing a whole range of laws and other legal sources that govern the legal framework relating to ships and their operation. It includes a variety of legal systems, ranging from international law to regional and national laws and down to local rules. It covers issues of public concerns. You'll all be familiar with some of the huge environmental issues that have arisen out of major pollution incidences from ships. Safety, security, piracy's become a really interesting issue for us. Cyber security is now something that I'm dealing with a lot. Environmental protection, as well as civil law matters, contracts of carriage, liability and compensation for damage, salvage and rules relating to marine risks and insurance, to name but a few. So I'm going to use this course to teach a lot of fundamental legal principles, particularly on contract law, using shipping as a framework. Okay, so you'll get a really practical overview on how you stand up and get into court, get in front of clients and advise them on these issues, particularly contract. Okay, here's some pictures just to give you a flavour of maritime law. Beautiful example of the rights of two vessels in the Auckland Harbour many years ago. Somebody on a surfboard and an American warship. Okay, our job is to work out what's going on here from a legal perspective. Who's got the rights? Who's got the obligations? Does that warship have to stop for somebody on a surfboard? Okay. What happens if there's damage? What happens if the ship stops, can't move? Okay. These are the kind of things we'll be looking at. Here's a man in the Western Sahara. I'm dealing with this right now. He's a member of the People's Front in the Western Sahara. So far not registered or known as a UN country. They claim to own all the phosphate in Morocco, in the Western Sahara. It's the best phosphate in the world. New Zealand needs it. He, along with his group, claim ownership of it. Okay. The Moroccan government thinks otherwise. The Moroccan government sells a whole shipload of that product to New Zealand, and the ship arrives in South Africa. And legal proceedings are started that stop that ship from moving anywhere else in the world. That ship is arrested. The only thing you can arrest other than a person is a ship. Okay, so how does that happen? By a fantastically developed historical process which allows maritime lawyers to do that. Okay, you stop a ship, take the cargo off, and there's a substantial, that cargo is worth a fortune. There's all sorts of interesting legal issues that we're dealing with on that. Okay, ship runs aground on the southern coast of England. Okay, this is happening all the time. You'll see this happening in Auckland. All the containers fall in the water. They start going ashore, and look what happens. People from Cornwall decide that they're entitled to the contents of the containers, particularly wine and rum. They claim, I'm not joking, they claimed historical Cornish rights of collecting what comes ashore on the beach. Completely wrong. The collector of customs in the UK had a completely different idea. The same things apply here. Does that happen in New Zealand? Sorry?
I've been watching Poldark.
They've been watching Poldark. Okay, this is maritime. The issue as to whether those people are lawfully taking that cargo away on the beach and can help themselves to it is a really interesting area of maritime law. Okay, some Australian scientists were down in Antarctica a couple of years ago, and I was involved in this case. They decided that they had to get back to the ship. The captain of the ship says, "Get back. There's some ice coming in. I need you back quickly on the ship." The Australian scientists go, "Well, we're not in such a hurry. What's the problem?" They take their time to get back on board the ship. What happens? The ship gets stuck in the ice. Okay, big issue then for me to advise on. What happens next? The cost of getting those people off the ship, as opposed to leaving them there for a few weeks, and I was all for leaving Australian scientists as long as you need to, as opposed to incurring millions to get them helicoptered off because they were a bit concerned about the cold, raises all sorts of interesting issues. Okay, contractual law issues that we're involved in. This is the Rena. You'll all be familiar with that, of New Zealand. The master of that ship was totally at fault for putting that ship on the reef. He paid nothing for any of the damage to the cargo. Okay, so how can that be? You think about some of the contractual things you're thinking about, our liability regime for domestic sale and purchase. This is quite different. Okay, but it's absolutely happening all the time, and there's a lot of maritime law issues just in that photograph alone. This could happen in the Auckland Harbour. Big ship coming in and some people just out there enjoying themselves. I've dealt with those cases. We look at what's going on here, who's got rights of way, who's responsible for the damage, what happens if the ship gets held up for two days while they try and collect the boat off it. There's some really interesting liability issues and compensation issues. Maersk the other day, the biggest carrier in the world, had a cyber attack which stopped their entire logistics systems. They didn't know what was in any of those containers for 2 days. All over the world, delays to ships. Oh, sorry, I'm running out of time. Here's the future. We're looking currently now at unmanned ships, the liability regime. We're going to talk about all these issues. My last favourite shot, somebody's canoe's capsized, got on board a submarine. Okay, there's some lovely issues in there. We're going to do the course by having 2 lectures a week in the evening at 5 o'clock because I'm working. 5 o'clock in the evening, 8 o'clock on Friday morning, on Friday morning. So Tuesday 5 o'clock, Friday morning at 8 o'clock. We're going to do a course assessment by running a couple of scenarios, which I'm going to get you all to go and research and write back about. I'm going to choose about 3 different potential problems, go research them and hand that back in. That's going to be 20% of the course. Towards the end of the course, we're going to start talking about major casualty, pulling it all together, and the exam is going to be focused on sitting down and looking at an actual real life scenario and analysing it for yourself and working out what you've been taught. These are some of the answers. This is some of the advice you might give your clients. Okay, so that's maritime law.
Great. Thank you. Well, now here is an entirely new elected prophet for the first time in 2018.
Thank you. So my name is Stephen Price and I'm the head of the construction division at Minter Ellison here in Auckland, heading up about 30 odd construction lawyers, which gives a certain amount of idea of just what is happening at the moment in terms of both the construction law practice, what's going on in terms of construction and where we think it's going to be going in the future. I'm really excited to be offering and presenting the course next year. It's astounded me that it's taken this many years with respect for the universities to pick up on it, particularly when there have been, for some years now, substantial specialised practices around the country, and what we are seeing nowadays are that firms are realising more and more just how important the practice of construction law is going to be. So what is construction law? And I like to think about it, without unfortunately the same pretty pictures, as if you think about if you're going to build a building, what happens? And it's quite a long life cycle. You've got to get planning underway, you've got to get the contracts, the procurement, your statutory requirements all set up. You've actually then got to build something and get all of the specialist people to be able to build that along the way. At the end of it, you've got to make sure that it's in time, how it's going for budget, how it's going in terms of quality, your local council requirements all signed off, and then your reconciliation at the end, what we call project close off. and invariably then, depending upon the project, anything up to the next 15 years of your life spent in litigation. Fingers crossed, that's where I come in. So, as you can see from that, that has quite a wide range of issues. They are primarily contractual and primarily statutory. In the first half of that, there's a lot of government procurement rules you need to understand, a lot of governance issues that come up. And then at the latter half, or what my colleagues unkindly call the back end part of the practice, you end up having very complicated, technical, both legal and in terms of expert concepts, litigation. And I often say to people, if you really want to become a litigation lawyer, do construction law for a while. I've got a number of disputes partners at work. I spend more time in court, whether it's a High Court, Court of Appeal or Supreme Court, than any of them because of the nature of the projects. The types of legal matters that we'll be having to deal with are going to obviously not just be general contract law, but really digging into what we call the trinity of time, cost and quality. Many people have talked about the idea of good, cheap, fast, pick any two. And the practice of construction law is actually trying to pick all three, trying to find a way that the legal risks, protections and frameworks are in place so that time is controlled, cost is controlled and quality is controlled. And every single one of those matters you can dig into, whether it's contractual, whether it's going to be statutory, whether it's going to be even into areas in tort. The important area that I see for New Zealand at the moment is that we know that this demand is only going to increase. So there is going to be an increased demand for construction lawyers over the next 10, 20 years. But what is wonderful about construction law is that the concepts that we practice in New Zealand, whether it's in relation to the litigation or the procurement or the advice, any of those concepts are essentially the same whether you go to England, America, Australia, the Middle East. And so it's a very international practice, and that means our practice and the practice of construction law has the international relevance, but it also has the international opportunity, as unfortunately I see all too many of my staff now working overseas. As far as the course is concerned, it's intended to be 2 lectures a week, a 2-hour and a 1-hour, both in the late afternoon because I too have to work. I'm going to be assisted by a couple of my colleagues. I'm going to have Taylor, who's over here with me, assisting. One of my fellow partners, Janine, who also has a lot of involvement in the disputes part of it. But we're going to be assisted by another of my partners, Sarah Sinclair, who's considered to be New Zealand's top energy and procurement construction lawyer. And so she'll be able to talk to the government aspects, the procurement aspects involved in those. The assessment is going to be a 1,500 words written assessment and also an open book exam. I was tempted to make it a lengthy research paper, but my view is that the important part of construction law at the moment is going to be that the knowledge, the understanding and the practical ability to be able to do something on the fly rather than have to research it, because that's where, from a practice perspective, the real demand is. I've tried to keep that within 5 minutes, but I'm very happy to take any questions if I've missed out anything that people want to know about.
So just
Very
to add, construction law will be in the second semester and the prerequisites are contract and tort.
Very good. Thank you.
Thank you, Stephen.
Kia ora tātou. My name's Hannah Blueberg, if you haven't met me yet, and hope to meet some of you next year. So Administrative Law is the course that I will be, the elective course that I will be teaching. And it's not new, but it will be different next year from this year, because this year 2 of my colleagues taught it, so they ran quite a different sort of course. If you talk to past Administrative Law students, last year's version is a better guide to what you will find next year. So I taught it last in 2016, and I'll be teaching it again next year. And obviously I always develop it, but it'll be sort of similar to last time I taught it. So what's administrative law about? You will have come across an introduction to that in public law, so it's a part of public law. It is the law that governs decision making by public authorities and public entities. So For example, I go into the community law centre once a month to run a clinic there on administrative law, and the kinds of clients that come there, the issues that come up pretty much all of the time, the issues I deal with are to do with WINS, work and income, decision making, ACC decision making, and Housing New Zealand decision making. Right? So that's an example of the kind of entity that we deal with. Immigration would be another example, but they have a separate specialist clinic on that, so I don't tend to deal with that. But that's also the law that governs immigration decision making is very much part of administrative law. As is resource management, to some extent construction law, where it comes into building consents, that kind of thing. So it ranges right from very much individual decision making that affects people's lives and important personal interests to commercial interests, so Commerce Commission decision making, for example, or construction consenting for large projects. So it's relevant at both of those ends. And the law, when we talk about the law that governs this kind of decision making, there are essentially 4 aspects to consider in that context, and this course focuses on 3 of them. The first aspect that this course doesn't focus on is the substantive set of rules in each area. So the rules that govern immigration permits, or the rules that govern welfare benefits, or eligibility for social housing, or competition rules that Commerce Commission applies, right? So if you want to study the substance of those rules in detail, you'll be going to specialist courses like immigration law, etc. But in order for those rules to operate in those contexts, there's also a general set of principles that govern decision making by public authorities, such as fair procedure, adherence to the law, not taking kind of irrelevant considerations, not disappointing legitimate expectations, etc. So that's the second aspect of the law that governs decision making by public authorities, is the set of general principles that governs all of those kinds of decisions. And that's the first thing that we do study in this course. And the remaining 2 items are sort of more remedial or process oriented. So the next element, the next aspect is what is the role of courts in supervising this kind of decision making. So one of the main remedial avenues is judicial review, and a huge amount of energy is spent on deciding just exactly to what extent judges are justified and it's appropriate for judges to substitute their decisions for those of the decision maker who's authorised by statute. Right? So that's the third aspect, the second that's studied in the course. And the final one is, I said judicial review is one avenue of where you can challenge decisions. It is really only the very last resort, it's really expensive, etc. So the final aspect of the rules that govern decision making by public authorities is the design and criticism and understanding of other avenues that are available for challenging decisions. So what sort of avenues of recourse do we want, and what avenues of recourse exist in terms of internally applying for review, in terms of having specialist tribunals, etc. All of those are the kinds of, if you're unhappy with an ACC decision or an immigration decision, you're much, much, much more likely to be able to go to that kind of thing than to the High Court for judicial review, and that's what we also look at. Now, so the final thing I want to say about administrative law as a subject then is that it really is the sort of foundational subject of public law. If you want to at all practice in public law, you'll find administrative law everywhere. If you want to be a human rights lawyer, where the primary avenue for protecting human rights in New Zealand is administrative law proceedings. If you want to protect international obligations, again, within the domestic system, the primary avenue is administrative law. So therefore, I would commend to you, if you want to be a public lawyer, to see this really as your foundational course. So that's enough about administrative law as a subject. Finally, on the sort of course details, I don't remember off the top of my head what the timetable is, but I'm sure you can look that up for yourself. 4 hours a week, and will be 2 times 2 hours.
Thursday night.
And mercifully not at 8 o'clock in the morning, as I had it last time. So yeah, 2 hours twice a week. And the assessment, I have to tell you, I haven't decided yet. I only found out last week that I actually do get to teach this course again, and before that I was told someone else was going to teach it. So I haven't decided that yet, but I can tell you that will definitely be an assignment, which is of course actually compulsory now in law school. And almost certainly I would follow my usual practice of having the final exam as a take-home exam, which sounds scary to some people, but actually gives you much better opportunity to put your best foot forward, which is why I do it. And I think that's all that I wanted to say. Any questions? Well, I hope to see some of you next year, might well.
And I had just one thing to add about that course, and that is that if you look at the list of prerequisites on this sheet, administrative law appears to have no prerequisites, whereas in fact the prerequisites are public law, torts, and contract. So only crimes of the Part 2 courses does not need to have been passed before enrolling for admin. Michael.
I'm supposed to be here talking about tax, but what I'll do before I do that, I think, is put in a plug for Matthew Flynn's maritime course. On account of Matthew happens to be someone that I've known for a long time, and he's a terrific chap, and he is also a fantastic lawyer. And up until now, I have been the best sailor in the law school, but sadly, now Dean tied him, I'm only the second best sailor in the law school. So that's Matthew's maritime law course. Tax is, there are several reasons you might want to take a tax course. One is if you might want to be a tax specialist, specialise in tax law. You can do that in the private sector, working for a big law firm or a big accounting firm or in the revenue. But you also might want to do in any kind of commercial law, any kind of property law. You basically need to know how the tax system works. You need to know if your client is selling a property, in particular if your client is selling a property, are they obliged to pay income tax on the profit? Because sometimes they are, sometimes they're not. And are they required to pay GST on the proceeds of selling the property? Because sometimes they are, and sometimes they're not. There are 2 tax courses. There's the basic tax course, which happens in the first semester and again in the second semester, and there's the advanced tax course, which happens in the second semester. If you want to be a tax specialist, then obviously you should do both of those, and probably if you want to be a specialist commercial lawyer, you should also do both of them. It's a fairly specialised field, tax, but it is also something that is fundamental to the operation of the constitution and the political system and the economy. So, for example, at some point this afternoon, theoretically, we might get to find out who the government is, and the way that will work is that there will probably be what is called a confidence and supply agreement, which is something you've probably heard of and possibly know what it is, but in case you don't, what supply means is supply of money. Because it might be the case that Parliament can't enact any legislation, and maybe if Parliament can't enact any legislation, they enact hundreds of statutes every year, and if they can't enact any more, maybe we've got enough, and that wouldn't actually do any harm. However, if the government can't spend any money, then we have some kind of a constitutional crisis happening, and the government cannot spend money unless it has a law authorising it to do that, and that is where Winston comes in. Because obviously the government cannot pass a law authorising expenditure of money unless Winston agrees. And that is basically the leverage that he's got over the political system at the moment. So this constitutional importance of tax law that's the current example of it, but it's something that is fundamental ever since pretty much Magna Carta, which I guess you might have learned about in your constitutional law class at one point. Is the point of Magna Carta is that the king cannot require people to pay taxes. The Crown cannot require anybody to pay tax unless there is a law requiring the payment of tax. That's what Magna Carta is about. What else? The way it works is whoever gets the best marks typically gets a job at one of the big law firms. Whoever's sort of next one down gets a job at one of the big accounting firms. Whoever gets the next one down gets a job in that revenue. Then what happens is whoever got the job at Chapman Tripp emigrates and goes and gets a job in London, and everybody moves up one. Unless possibly by the time you work in the revenue department, you might have discovered you like going home at 5 o'clock. And the sad truth is that you've got the job at Russell McVeigh, the chance of going home at 5 o'clock is sadly fairly slim. The basic tax course covers the whole of the tax system with a little bit of theory of how a tax system will work at the beginning, and the most of the course about income tax and GST at the end. The advanced tax course is got 3 parts. The first part is more sort of theory and policy of how a tax system ought to work. Questions like, for example, whether we ought to have a capital gains tax. Second part is all about corporate tax, which is kind of the nitty-gritty bit of it, and is the bit that most employers want you to know about. And the third part is international tax, which is kind of a growth field, because whenever you've got cross-border trade or investment of any kind, partly that presents the problem of maybe it's going to be subject to tax in 2 different countries, but also maybe it presents an opportunity because maybe you can organise it so you don't have to pay any tax in either country. So it's a growth area. We cover all of that. That's about all I've got to say. Anybody got any questions? No questions?
Kia ora tātou. Hi everyone. I'm going to be teaching a course on Indigenous peoples and international law this summer, and so it runs from the 12th of January to the 9th of February. It's taught on a Monday, Wednesday, Friday 1 to 4, and it's a 15-point course. And the aim of this course is to introduce students to international law, especially human rights law, relevant to Indigenous peoples. So if you've got a curiosity about Indigenous peoples and the law, about international law or human rights law, then it could be of interest to you. I think that an examination of the international law regarding Indigenous peoples is relevant for us in many ways, so it's got some scholarly value. So when we look at Indigenous people's relationship with international law and its institutions, it actually helps to shed some light on some interesting shifts that have been going on in the international legal system, including the growth or proliferation of law and law-making institutions, and also the growing participation of non-state actors in those institutions. It's also really timely. There's been a lot of activity going on at the UN in relation to Indigenous peoples in the last few decades, and that's been crowned by the adoption in 2007 of the UN Declaration on the Rights of Indigenous Peoples, which provides really clear articulation of Indigenous peoples' rights norms. There's also been a bunch of institutions that have been established within the UN that's focused exclusively on Indigenous peoples. So we've got, for example, the Permanent Forum on Indigenous Issues, the Expert Mechanism on the Rights of Indigenous Peoples, and the Special Rapporteur on the Rights of Indigenous Peoples. And in addition to that, you have a whole bunch of jurisprudence coming out of the human rights bodies that are monitoring the major UN human rights conventions. So those bodies are also commenting on Indigenous peoples, and then some specialised international agencies such as the World Bank Group and the World Intellectual Property Office are also focusing attention on Indigenous stuff. So it captures quite a lot of different subjects in that space. It's also got a lot of practical value. So we know that there are around 370 million Indigenous peoples around the world, reflecting about 5,000 different collectives, 5,000 different peoples. And in all of these countries, unfortunately, Indigenous peoples tend to be overrepresented in negative socioeconomic statistics and also marginalised in terms of their positions of power. So understanding international law relevant to Indigenous peoples can be one more tool in that tool belt for trying to advocate for better recognition of Indigenous peoples' rights. So the course is going to focus on a whole bunch of different topics, and they include who are Indigenous peoples. We're going to explore this Declaration on the Rights of Indigenous Peoples. We'll look at some of the justifications for Indigenous peoples' rights. We'll look at these UN institutions and Indigenous peoples. We'll examine some of the monitoring of states that's gone on by the UN, and we're going to focus on New Zealand and Pacific states. And we're also going to talk about the domestic relevance of international law regarding Indigenous people. So what does it mean when we bring it back to countries like New Zealand and elsewhere? We're also going to mention there's some important jurisprudence that's coming out from regional human rights bodies, especially the Inter-American Court and Commission on Human Rights. So we'll look a little bit at some of those bodies as well. And we're going to focus in particular on some really key rights, including Indigenous people's rights to their lands, territories and natural resources, and the right of Indigenous peoples to have their free, prior, informed consent obtained before decisions are made regarding things affecting them. So this course is actually run in collaboration with the University of the South Pacific in Vanuatu. So the course is going to be taught half in Auckland and half over there, but unfortunately you guys don't get to come to Vanuatu. What it means is that for one half of the course I'll be in Auckland teaching it here with a video link going back to USP in Vanuatu, and then for the other half it'll be the reverse, so you'll have a video link and I'll be in Vanuatu. But it's a really exciting opportunity to have these, have students from the Pacific contributing to these discussions that we're having in this important rights space. So it's a really exciting opportunity there for us. There are 3 pieces of assessment for this course. So there's a group presentation on a topic that's covered in class. Basically it means when you start the course, you will get assigned into a group, and your group will be leading a class discussion on the set readings for a particular lecture during the course, and you'll do that during class time. And that'll be worth 20%. There'll be a 1,500 word reflective essay reflecting on the content that we've covered in course, and again that's 20%, and then there'll be a 60% exam at the end of it. So that's all that I had to say, but it would be really fantastic to see some of you in the course, and if you've got any questions you're welcome to ask me now, or if you spot me around to ask later.
Okay, so personal property, why would you take it? Well, because it deals with, firstly we start off the boundary between real and personal property. What is personal property? Probably have no idea. Well, it's anything other than land. So we distinguish between land and personal property. You may think that's not hugely relevant or significant, but believe it or not, you will find, for example, somebody owns a factory, they have heavy duty equipment. Question, who owns it? The person who owns the equipment or the person who owns the factory? We touch on interest in personal property. Most of the course deals with tangible personal property. In other words, anything pretty much not tied down. This, what I hold here, is personal property. We look at possession, which may seem a simple concept but can get difficult. We also consider different kinds of possession, and then we move on to the Personal Property Securities Act, only about 1.5 classes. But the purpose of that is just to make you aware of a very important piece of legislation. It affects, as the title tells you, security over personal property. We move on then to the finder's cases. In other words, what if somebody leaves property? Let's say I leave my watch in somebody else's field. Well, I own it, I have the primary claim. But what if I disappear? What if there's now a contest between the occupier of the land and somebody who happens to be walking across it? A lot of the course will then turn to bailment. Now, bailment is a very simple arrangement. It's nothing more than my tangible personal property. I give it to you. You are now my bailee. So common, and yet the concept is not clearly understood. And we will look at what are the consequences of another person holding goods that belong to somebody who has a superior claim. And it has not just personal implications, but also commercial as well. You can play out these various concepts in very profound commercial contexts, like, for example, the carriage of goods by sea. Okay, that then is the entirety of the course. We have a 30% case note, and then the balance 70% is assessed by an exam. The case note is fairly new. But what I'll do is I'll give you a case. You will have a number of weeks to review it and then submit a case note of considerable brevity. And the challenge is not to write something long, but be constrained by, and I haven't quite decided, probably about 1,000 words. What you'll be screening for is more words, and the answer is you won't get more words. So it will challenge you to approach in a very concise, logical, and targeted way. And it will give you a very useful skill in terms of analysing cases. Okay, any questions or comments? If none, okay, thank you. Thank you, Stephen.
Talofa lava everyone, my name is Tuan Asafo, and I'm going to be co-teaching South Pacific Legal Studies with Helena Kaho. Essentially, this paper is all about producing a research paper, because what me and Helena are really passionate about is building scholarship on South Pacific legal issues, because there's simply not enough. There's like one article published every year, so we want to try to generate some critical thought about the South Pacific and our unique constitutional issues. So basically for first semester, we'll be looking at the unique historical, social and economic context that islands in the South Pacific exist in, basically looking at how colonization imposed this whole unique new political and legal system onto us, and the unique issues that resulted from that. And then in semester 2, we'll be looking at particular current issues in our constitution, specifically the conflict between human rights and constitutional values, such as in customary law in the different Pacific islands. We'll be looking specifically at feminism in the Pacific and jurisprudence around that. How Pacific women and the intersectionality between that in terms of land law and sexual assault cases as well. We'll also be looking at dispute resolution. In the South Pacific, we have a very unique way of handling our disputes and how that compares to traditional Western systems. We'll also be addressing issues such as tensions and legal pluralism, trying to resolve the conflict between Eurocentric points of views and perspectives and our collectivist way in the Pacific. In terms of our course assessment, it's all going to be designed around that research paper. So first we'll be having a research proposal of 1,000 words worth 10%. The reason why we put this forward is because we wanted students to start thinking about their research topics as early as possible, rather than towards the end of the semester when they are due. So making sure that you consult with me and Helena about the topics and get that sorted. And then we're going to be doing a presentation as well, which will be, we have the research proposal, which will be worth 10%, the research essay worth 75%, so a large chunk worth that, which will be 5,000 words. And then there will be, at the end of the semester, the opportunity for students to present their research in front of the class and receive questions and commentary from their peers. Are there any questions that anyone has about South Pacific Legal Studies?
Hi everyone, my name's Anna, and I'm taking refugee law over the summer, as Stephen said, beginning in early January, really, 9th of January. It is totally worth giving up your summer holiday to come and do refugee law. I think one of the biggest issues that we face globally at the moment is the refugee crisis, and it's something that's not going away anytime soon. I think in all our lifetimes it's going to be one of the really big things that as an international community we need to think about and tackle. There are currently 65 million people who are displaced from their homes for a whole range of reasons, from war to climate change, famine, political persecution, religious persecution, the list goes on and on and on. What we do in refugee law is look at the system the international community has created to try and help at least some of those 65 million people. So we're going to look at the development of the refugee system that has sort of been developed since the 1950s, and then we're going to look very specifically and spend quite a bit of time looking at exactly who is a refugee and what the legal definition of a refugee is. We'll look at who's excluded from it. We'll talk a bit about the process of actually bringing a refugee case and the difficulties of proving your case as a refugee and how the system sort of deals with that kind of thing. And then we'll move it on to look at some policy issues around a range of different topics to do that are sort of connected to refugee law. We'll look at detention issues. We'll also look at the extent to which the refugee system fails to sort of accommodate many of the people who have been displaced and some of the limitations of the system. It's going to be a great course. I will be lecturing parts of it, but there's also a lot of room for discussion, and I'm very keen to get everyone who's taking the course involved in a range of different exercises. I also try and bring in a range of different guest lecturers, so people who are working in the refugee field. Some of them work here in New Zealand in refugee law and are judges or lawyers here. Others have experience working in refugee law overseas. There's also, for those of you who take the course, every year I run an internship program with the refugee court here in New Zealand, and the only people who are eligible for the internship program are people who have actually taken this course. So something else to keep in mind if you're interested in it. In terms of the logistics, it takes place over 4 weeks in January. It'll be taking place 3 days of every week and 3 hours every day. So basically Tuesdays, Wednesdays and Thursdays we'll have 3 hours a day. The assessment will be a test after the first 2 weeks, and that will cover the first 2 weeks of material, and then there'll be an exam at the end to cover the rest of the material.
Yeah, my name's John Land. I'm a barrister at Bankside Chambers. I contract in for company law. So I've been in legal practice for 31 years. 26 years at a firm called Kensington Swan, 20 years as a partner, and then 5 years at Bankside Chambers. And company law is a really important subject if you want to work at a law firm or become a barrister, because it affects so much of what we do in practice. And I certainly know from having looked at or been involved in recruitment rounds back at Kensington Swan that you have to have done commercial law, company law, to get to the next stage, to the interview stage. It's sort of, like Stephen said, it's not compulsory, but it sort of is compulsory if you want to work in private practice, in most firms anyway. So it's really important from that point of view. Assessment, 15% on a 1,500 word assignment, which would be a problem question, probably a company contracting problem question. And then the rest is an exam, 85% on an exam. And this style of this has changed a little bit. If you're looking at past exams online, I presume that it's available for you to do that. You might see that normally there's been four problem questions, and you're thinking, oh my gosh, 4 hard problem questions over 3 hours, that sounds pretty grueling. Well, I've changed that from this semester on. It's now 3 questions over 3 hours. So it's less of a speed test and more of a true test of your analytical ability. In terms of the teaching style, what I've tended to do with that is my PowerPoints are limited to visual descriptions of cases and a few quotes, which we then talk to. So let me just give you an example. Sort of example of a case where we show the relationship between the parties, and then we talk through, what happened in this case, what legal issues arise under the case, and so that's a sort of a standard sort of slide showing the relationship between the parties. Sometimes I'll add to that with a bit of a chronology, but what you're not going to get is a whole lot of detailed words, which is going to just make it hard to sort of think about the cases that we're talking about. So that's an example of a chronology, but that's fairly unusual. It's usually just the first sort of slide I showed you. And then the other thing that we do in the course is at the end of each section of the course, we do some practice questions. So you've just learnt about, say, directors' duties, and you've learnt about cases like the case that was on that previous slide. So then let's cement that by looking at a sort of a sample question, the same sort of question that you might get in an exam, and we'll go through that together, we'll work through that together. So we do that at the end of each part of the course, and then at the end of the course, in the last 2 classes are completely review prior to 85% exam. It's a bit daunting, right? So we have 2 classes where we go through mock exam questions which I've prepared, and we work through those together. So you get a bit of practice at spotting issues, analysing the issues, and talking about how you would then write an exam question. So that's the sort of approach that I take to the course. So, any questions on the approach to the course, or why you should or shouldn't do company law? And you definitely want to do commercial law too. But you'll hear about that in a minute.
Good. So I'm Anne Hertogen. For those of you who don't know me, I teach commercial law elective here. And so basically we cover 4 statutes in this course, and we cover them in a fair amount of depth. The first one is a part of the new Contracting Commercial Law Act, where we deal with the regime of selling goods and where we learn how you transfer property in goods, for example. So if you were to go to, say, whatever shop comes into my mind, nothing works for me at the moment, and you buy a new thing, say a new laptop, at what point do you actually become the owner of that? What if things go wrong? What are your rights? If there's nothing in the contract, where do you go and look? What can you do? What redress do you have? And then we contrast that with the specific regimes that would apply to consumer goods that are in the Consumer Guarantees Act, and have a brief look at services as well, if time permits. And we look at the Fair Trading Act as well, sort of the main disciplines of that, because we can't cover everything in depth. I think Rob covers some of that too, doesn't he? And then the second part of the semester we deal with PPSA, the Personal Property Securities Act, where we look at how you can use property and goods as a way of securing other obligations and how you do that. We look at when you have one of those interests, we look at when it becomes enforceable, what you need to do to protect your situation, and then we look at what happens when everything really goes to custard. And there are multiple creditors who all want to have that same particular good. How do we divide the pie? So a lot of that second part of the course is devoted to that particular question. So a variety of topics that all come under the wide banner of commercial law and things that you might encounter on a regular basis, or sometimes maybe not so regular, when you go into commercial practice. Course assessment, I haven't fully decided yet, because I have experimented this year with reading quizzes, which are quizzes that the students have to do before class on Canvas, and really isn't extra work. They just need to do the cases, which of course they're all reading before class, aren't you? And so I've had 5 of those this year, of which I've students had to, or of which the best 3 scores counted towards 15% of the final mark. I am waiting for the current set evaluation to close to see how students feel about those. I quite like them, and I'm thinking I might extend that next year so that maybe there'll be 4 of them or 5 of them that will count to 20% of the grade, but more options, so almost a reading quiz for every class, and you choose a certain number of those to go for your final grade, and the rest would be an exam, most likely a 3-hour exam, because I found it quite difficult this year to set appropriate questions for just a 2-hour exam. So, but assignment is still to be determined, whether there's a written assessment to the mix as I did this year, but probably not.
Thank you, Stephen. So I didn't really know what to do in this. It sort of felt like a bit of a show and a tell. So when you're going to talk about trademarks, you've got to bring along trademarks. And I like John's slide actually, because I'm a bit of a trademark geek. So when I saw John's slide, I thought, well, that's a nice trademark Port of Tauranga has got there. And when Arne was talking about laptops, I was thinking, there's an Apple logo. It's always shown in my lectures. But anyway, this is a course, a 10-pointer course, trademark law, for those who know something already about intellectual property. So, if you know something about intellectual property and you've done Paul Sumter's intellectual property course, and you want to find out more about why Coke has a shaped trademark and how it had difficulty enforcing this trademark against Pepsi. And this is the course for you. So it's a course where we will build on foundational knowledge of intellectual property and trademarks. And we will deep dive into some of the curly issues that face New Zealand's trademark law. We'll also look comparatively at other jurisdictions who confront similar issues. The course will be 2 hours of lectures per week. I think they are Wednesdays and Fridays. The assessment will be an exam, but also a problem type question, which will be really a realistic type problem that you would face if you had to advise somebody about a trademark legal issue. And that'll be 1,200 words or thereabouts. Why should you worry about trademarks? Well, of all the intellectual property rights, New Zealand businesses use trademarks most of all. They're the most used instrument by New Zealand businesses. So if you're interested in company law and commercial law, chances are you're going to come across trademark issues, be it trademark licensing, be it issues with the sale of goods bearing trademarks. So really useful sort of general skill to know a bit about trademarks, but also it could be useful if you went down the track of thinking about being a patent attorney and dealing with trademarks as part of your day-to-day practice. But that's it for me. Trademarks 10 points. It's in the first semester next year, and it's Wednesdays and Fridays. Questions?
So is intellectual property a prereq?
It is, yes. Any other questions?
My name is Nikki Chamberlain. This is my first year lecturing actually at the University of Auckland, so next year will be my second year, and as Stephen has kindly said, I will be involved in 2 electives next year. So the first one I wanted to talk to you about, I was going to start with a question, which is, what do Married at First Sight, Hugh Hefner's death, and poor old Crystal being left out in the cold, not getting anything, not inheriting anything after he died, and Brangelina have in common? They all have to do with family property. And so essentially the course of family property is going to be second semester. It is 15 points. We will be covering a number of really important topics. We will be covering relationship property. What is relationship property? What happens when you separate and you do not have a prenuptial agreement? What happens when you separate and you do have a prenuptial agreement? Can that be challenged? What happens if all of your assets are in a family trust and you are only a discretionary beneficiary? Can you attack that family trust to get money out of it? What happens when somebody passes away, leaves a will, and you're left out of it? Can you challenge the will, or are you stuck with the fact that you've been left out of it? What happens if you know somebody dies and they don't leave a will? How do you know if you're entitled to anything from their estate? These are all things that are covered by family property. I personally love the subject of family property because it's not only relevant to legal practice, but it's very much relevant to all of our lives. I can guarantee when you go out into practice, you will most often be asked family law questions out at parties. Oh, you know, I'm getting married. Do I need to sign a prenuptial agreement? Ooh, how do I handle that? Awkward. Or, oh, my relationship's going pear-shaped. What does this mean? So it's a really fun class. It is taught at 8 a.m. I'm not a morning person. However, after doing a semester of it, I've come to love the 8 a.m. slot, which I am sure you all will too. It is recorded. As far as assessments go, 25% essay, and a 2-hour open book exam, which is 75% of the mark. So that's how it will be assessed. Any questions on family property before I hop on to privacy law? No? Good, okay, excellent. So privacy law, Stephen Pink and I are going to co-teach privacy law. Really looking forward to it. It's going to be a 10-point paper, first semester. It's going to be taught in a 2-hour block once a week, which is very manageable, bite-sized for you to all digest. Privacy law is a really exciting area, and the reason privacy law is an exciting area is because it is constantly changing, right? With technology, privacy is becoming a really big issue. Think about Facebook, right? All of your information which is on Facebook. Is it private? Is it not? What if you have a private profile? Think about Edward Snowden, right? He had private information. All of a sudden, he starts leaking that private information. What does that mean? Okay? What about privacy in employment? Your employer. What about your healthcare records? What about Broadcasting Standards Authority? What are the competing interests? So how the course is going to be structured is Stephen is going to lecture you for 6 weeks. He's going to be talking to you about concepts and definitions of privacy, competing interests as they relate to privacy. And he's also going to talk to you about the common law development of privacy. Because, as you probably all know from torts and your stage 1 class, UK, Australia, New Zealand, Canada, who have I left out? Australia, yep, all have different laws relating to privacy, just to make it really complex. So we're going to talk about all the different approaches to those, and then I will come in for the second 6 weeks, and I will be talking about the Privacy Act, what it covers, what you need to know, and then we'll be talking about specific case studies. So I will be going through stuff like Broadcasting Standards Authority. What do the media have to do when they're reporting on things? Are there privacy requirements that have to be met? I'll be talking about privacy in employment law, for example, privacy with your healthcare records. And I'll also be doing a really cool topic I'm looking forward to called the right to be forgotten. Okay, it's this new interest in privacy. So given technology, if you were to pass away or have a family member who passes away, they are going to leave an electronic footprint, right? On Facebook, for example. Well, what happens if you want to be forgotten, right? Think about the Tucker case, criminal conviction, okay? The right to be forgotten. Who's to say with the Clean Slate Act that after a certain period of time, that criminal record should be forgotten? But of course, with media now, all you have to do is a quick Google search, and that's going to be stuck with them forever, right? So we're going to be talking about all of those interesting things. What is really, really great about this course, if I haven't already sold it to you, despite the fact that Stephen and I are teaching it, is the assessments. So we're going to have a 1,000-word, 20% essay. But the cool thing with this is there are 3 different topics due at 3 different times in the semester. You get to choose. Amazing. Okay, that's very exciting. The other really exciting thing about this class is that 80% is an option as well. You can either do a 2-hour open book exam or a PILO, paper in lieu of exam, which is 4,000 words, and you can choose the topic of your choice to be approved by us, okay? And that's neat too, because you're kind of killing 2 birds with 1 stone. You have to do an extended piece of writing of 4,000 words for Law 499, is that 498, sorry. Law 498, you're required for your degree to do an extended piece of writing of 4,000 words. If you choose to do that in our class, not only will that be your final assessment, but as I said, you're killing 2 birds with 1 stone because you tick that 498 box, and you get to really delve into an area of privacy that you're interested in.
Good afternoon, everyone. For those who don't know me, I'm Dr. Henry Carr, I'm the course director of family law. Family law covers aspects to do with parenting and dissolution of marriage. It covers all the non-financial aspects of family law, as Nikki alluded. The family property course covers all the related property material. So why should you do family law? For 2 reasons. One is for professional reasons and the other is for personal reasons. Family law is a major area of practice. If you end up working in a suburban firm or even working for a boutique firm or a large firm in the city, invariably you will encounter family law, and it is a bread and butter subject that you really should be aware of. In regards to the second point, personal reasons, unfortunately, parenting disputes and the dissolution of relationships are ubiquitous in society. If you're ever at parties or talking to your friends, they find out that you're a lawyer, they might ask you for divorce advice. I've been asked a few times. Now, anyway, in terms of the content matter, topics that we'll cover include marriage and divorce, family justice system, alternative dispute resolution in family law, child law, so that covers adoption, surrogacy, and something known as the doctrine of the mature minor. And finally, we'll go through parenting disputes, so both domestic and international disputes. Domestic disputes are covered under the Care of Children Act, while the international disputes are covered either under the Care of Children Act or through the Hague Convention on the Civil Aspects of Child Abduction. There is both a domestic and international dimension to the family law course. In terms of the assessment, there are 2 pieces of assessment for family law. There is a 1,500 word assignment, which is worth 20%, and a 2-hour open book exam that is worth 80%. It will be taught in semester 1 next year. It will be taught on Mondays and Thursdays. Mondays between 4 and 6 p.m. and Thursdays between 4 and 5 p.m. Does anyone have any questions in relation to family law? Good, well have a good afternoon.
Hello everyone, nice to see you here. How about I not put that there? I'm Nina Kuri. I teach and research in dispute resolution, both theory and practice, with a focus on mediation. Mediation, for those of you who don't know, it's not meditation, it's not medication. I still get that the whole time. It's a process for resolving disputes out of court. And basically what it involves is getting around the table, face to face, talking about the problem and negotiating a solution by agreement. And all civil cases can be resolved by agreement, legally can be resolved by agreement without the need to go to trial. So it's always available to the parties to resolve their disputes by agreement. We call that settling the case, and every civil case you read in law school, whether it be in tort or contract or equity, is a case that didn't settle. Okay? So if I tell you that over 90% of all cases filed in the New Zealand High Court settle before trial, what does that tell you about the cases that actually result in a judgment for you to read at law school? What it should tell you is that it's only this much. Okay? What actually happens in practice is everything else. So my proposition, and why I really enjoy teaching this subject, is that as a lawyer, and actually in other contexts as well, I have lots of former students who are now practicing law in a non-dispute context, so particularly in commercial law, and actually in non-legal contexts, in management consulting and all sorts of other industries, is that actually there's a whole range of skills you need outside of mooting and courtroom advocacy. So how are most disputes resolved? Not in court. What skills do you need as a lawyer? You need skills in conflict diagnosis, you need skills in effective communication, skills in negotiation theory. Okay? And you also need to be thinking about, or what we talk about in this course, is the wider civil justice picture. It's a fundamentally different ball game in the negotiation and mediation context to represent your clients effectively. It's a whole different set of skills. So that's what this course is all about, getting to grips with those skills, both the underlying theory of negotiation and conflict, but also the wider jurisprudential civil justice context, and also practical clinical skills. So switching to And I should have said, in terms of who I am, I'm a member of faculty here. I also practice as a mediator. So I bring that professional practice to bear on what we talk about in the classroom. And you'll hear a lot of war stories and so on. Who should do this course? Across a wide range of practice areas, basically. Anyone who's thinking of going into litigation, I would suggest that along with evidence, the other course I teach, this is bread and butter stuff. You need to do it. If you're looking at going into family law, employment law, even if you're looking at practicing in criminal law, these kind of skills come up in the plea bargaining context, increasingly in the restorative justice context. And in commercial law, we're looking at negotiation skills for deal making. What do we actually do? The course is a mix of, I try and divide it into 50% theory, 50% practice, and that carries through both into the way that I teach the course and into the way that we assess the course. We have a limited entry. Most years we have a waiting list because we have an element of practical, clinical experience in it, which means that we simply cannot have too large a class. The assessment, as I said, 50-50 theory and practice. Half of it will be a research essay due at the end, which will be the theory component of it. That is a research exercise. I can't remember the exact word limit. It will be in the handbook in due course. But that is a very academic side of it. The rest is more practical. So we'll be doing negotiation exercises in class, where part of the assessment is preparing for that exercise and then reflecting on how it went from a negotiation theory point of view. There will also be an element of group work. In past years, that's been a group presentation on a specific topic like gender dynamics in negotiation or online dispute resolution. I'm in the process of reviewing that at the moment. It's possible we'll do some sort of online blogging type of exercise. So watch this space, that will be confirmed in the handbook. It's all internally assessed, no exam. The feedback I've had in past years is that people thought that would be easy and it turned out to be harder. Okay, so it's not a soft option. The other feedback I've got consistently is that it's one of the best courses they've ever taken. So take from that what you will. In terms of my teaching style, I like to run it as a postgraduate workshop. So we've got a small class. There will be a participation component. The expectation is that you get involved, you engage. I know your name. This is final year of law school stuff. It's a chance for you to bring something to the table as well and engage at a higher level. Questions?
I'd just say something about the timetable. We've scheduled it 2 mornings a week, total of 4 hours, but it's a 15-point course.
Okay, and we have it on, I think, Tuesdays and Thursdays, 9 till 11?
Monday and Thursday, 9 till 11.
Monday and Thursday, 9 till 11. Yes, thanks. There are 4 hours allocated, but it's a 15-point course. That gives us flexibility for the practical exercises. Okay, so we will not always go for the full 2 hours every class. What it means is that we can chop and change, and I know that you've got that time set aside. The assessment is calibrated to reflect a 15-point course.
Okay, hello everybody. As Stephen just said, I'm a barrister at the moment. I've been a practicing lawyer for 20 odd years, and I'm replacing Rod Joyce in the civil procedure elective. That means it will be a new course next year with a new teacher who's I hope going to bring a bit of a different perspective to the course, and I don't mean that in a critical way. I've spoken to a few people at Chambers who frankly said to me they didn't do civil procedure because they thought it was a bit dry. I then asked them if their experiences at Chambers since then might see them reflecting on that decision in a more critical way, and universally all of them have said yes. That tells you something about what you might expect to learn, because civil procedure fundamentally is an immensely practical course that will ground you in good skills if you are intending to enter a civil litigation type practice. I'm intending to make the course partly a practical course in the sense that I will be teaching you what the High Court rules say, and I will be explaining to you from a really sort of how to do it point of view, how you go about navigating what is a large piece of work that tells you, because it's just a collection of rules, how you run a piece of civil litigation. This is the stuff that will be the 10% Nina won't deal with. So it's the stuff that goes to court. It also frequently involves the 90% of stuff that does settle, because invariably a lot of those disputes have needed a court proceeding to kick it all off. So I'll give you the skills to be able to confidently and competently draft a pleading document, which is a document that tells a court what your claim is. You will come away from my course knowing exactly what an injunction or a freezing order is, and why you might want to get those things and how you might want to go about doing them. It's not just the practical side that I want to look at, though. I've failed if you come away just knowing a bunch of rules. I've succeeded if you come away knowing why those rules exist and with a confidence to be able to apply the knowledge you've learnt about general civil procedure rules into other areas where similar procedures are needed. Fundamentally, civil procedure is about natural justice and about ensuring that the parties in the court know what case is being argued and can argue fully and properly informed about all the facts. The High Court Rules is an extremely long piece of work. I don't believe it needs to be that long, and what I'd like you all, if you did my course, to understand as an outcome of that is what's wrong with those rules as well as what's right with them. There are many different ways in which a civil procedure or a set of procedural rules applies in New Zealand, not just the High Court rules, and there are many simple ways in which basic procedures are deployed. So if you approach the course the right way, not only will you come out with practical skills, but you'll have some reasoning and critical thinking skills that will enable you to confidently look at any procedure and say, well, I know it's written a bit differently from the stuff I learnt, but fundamentally it's trying to achieve this purpose. Finally, there's a bunch of new things that have been happening over the last few years in relation to civil litigation actions. You'd have read about a number of them in the newspapers and things. They're interesting developments of civil procedure and the way in which New Zealand civil procedure is growing. I'm talking about things like class actions and litigation funding. If you're at all aware of the things that are happening in New Zealand, you will see more and more of these things happening. And there are rules that are slowly being brought into place that tell us how we need to deal with those sorts of things. So by class action, I mean the kiwi fruit growers, for example, are involved in a big lawsuit in the High Court in Wellington at the moment, where they are saying that the government failed them in the government's obligations to keep PSA out of New Zealand. You have a large group, hundreds of people, who all say they've suffered losses. So we have rules around how they can have their day in court, but only one day in court because they've all basically got the same issue. Litigation funding is increasingly relevant because litigation is expensive and people can make money out of funding litigation. And in New Zealand there are now a number of established companies that offer litigation funding options for people to enable their case to go to court. And you'd have probably read about a lot of some James Hardie actions at the moment, where people are suing James Hardie and a number of other producers of housing products for defective products that end up on their houses that mean their houses leak. So it's an exciting little area. I'm not going to make it a dry area. I don't really like standing up in front of a lectern, but like Nina, I'm not sure how many people are going to enrol, but we'll adapt, I think, the course to make sure that practical exercises are assessed in a practical way. So there's no point in examining people on practical exercises. There is a point in examining people on conceptual understandings. I've putting my head to how we're going to assess the course, and you'll have to wait till the handbook to see that. But my own style is I very much like getting out from behind the lectern, participating with people, getting group collaborative things going, and that's an increasingly important skill that I think you'll find in practice, working as a team. So the PSA litigation is a great example. It needs a lot of lawyers to run a big case like that. So there's no scope for an individual there. You have to know how to work with a team of people to get the vast amount of information before the court in a coherent way. So hopefully I'll teach you some of those skills as well. I'm quite looking forward to starting this paper a bit from scratch, although Judge Joyce is my neighbour, so I'm going to sit down with him and ask him what worked about the way he taught it and what didn't. So, questions? Hi, Nina.
Can I do your course?
You can if you like. That would take us back a while, wouldn't it? That would take us back a long time. Yeah, Nina were you a student? It makes me sound really old.
No, you're not that old.
Not that old. I was at Russell McVeigh when Nina, I think, first surfaced there, weren't you? So that's how we first met.
That sounds like an excellent course.
Yeah, I mean, just a general comment from me. You've evidence. If you were going to think about, if I'm going to be a civil litigator, and I'm not saying you should make your decision about that now, but if that's really where you're heading, there are really some core topics. Nina's is one, absolutely. Because 90% of cases settle, so you need to know how to settle them and how to do the mediation and stuff. For those that don't settle, or to get them to the point of settlement, you might need to know a bunch about civil procedure. Now, a good question to ask me might be, well, one, I learned that at Profs, and if I don't learn it at Profs, what about learning that on the job? I didn't study civil procedure when I went through university. I don't even think it was offered when I was doing it. And the feedback I get from the juniors at Chambers is now, because part of the job they're given a lot of the time is read the rules and figure it out and come back to me with what we do here. They're actually having to spend a lot of time now learning things that they could have been taught. And then if they were taught, they probably would do better. No disrespect to Profs, but it's a pretty basic course that won't get into the depth of the things that I want to get into and won't give you the skills that you need. I'm selling it, but that's the reality. I've been in practice for 25 years. I've been frustrated by employed junior lawyers that don't know the rules. And when I've said to them, we need to get an injunction, quick, get the paperwork together, and I get a blank look because they don't know that they need an undertaking as to damages, and they don't know they need to get some information from the client about their ability to play an award of damages if the undertaking's called. It causes great frustration. If you want a leg up in terms of a future employer, being able to walk confidently into a partner's office and say, that looks like a summary judgment application to me, can I do it? Will get you miles ahead of the person that sits there blankly and goes, I don't know, what do we do? What's the procedure here? Okay.
All right, please do.
All right, hello to all of you here. So I teach evidence criminal procedure, Scott Optigan, associate professor. Evidence is also taught by Nina Corey, who was just here. I teach in the first semester, Nina teaches in the second semester. Evidence is about the study of how you prove things in court in civil and criminal cases. It's a basic standard survey class based on the Evidence Act 2006. We cover hearsay, privilege, opinion, relevance, prejudice, eligibility, compellability, opinion evidence, etc. So all the basics of the law of evidence. It's a course that is definitely useful and important for anybody who thinks they might be a litigator or might do any kind of trial or courtroom work, because the rules of evidence governs how you prove things in court. Like I said, we do cover both rules of evidence that cover both civil and criminal cases. However, most of the cases are sort of done out of the criminal jurisdiction for various reasons, because that's where a lot of evidence law gets made. It is, like I said, a survey class, a high level of class participation, reasonable amount of reading, and statutory references are strictly to the Evidence Act itself. All the materials are produced in-house. The only thing you really would need otherwise is a copy of the Act, and then if you want some outside reference, my own book on the Evidence Act, which is currently being updated to its 4th edition. So like I said, it is a good case for anybody thinking about any kind of trial work in your future, litigation, civil or criminal. Assessment-wise, it's a standard 3-hour final exam for a 4-hour-a-week class, and there's a written assignment component as well. That written assignment component can change depending on who's teaching it. It's how we want to do, but it's an opinion-like question. So that's basically evidence, and we are going to try to equalize the numbers between the streams, right? So next year. It's a very popular class. Many people who are in their final year take it particularly. And so we're going to try to equalize the numbers between the streams. We expect pretty full classes in both semesters. Any questions about any of that? Yeah.
How does this work represents for the 2 advocacy classes?
There are no, well, there's no prerequisites for evidence. I don't know, is evidence
the other way around.
Is evidence a prerequisite for advocacy now?
It's a
still?
Yeah.
It's correct.
Yeah.
It's a correct, yeah.
So you can do advocacy without, you can do evidence without advocacy.
Without advocacy,
but
yeah.
not vice versa.
That's right. Yeah, that's what it's been in the past. Yeah. All right, anybody else? Okay, so then moving on to criminal procedure. So criminal procedure is essentially the rules that govern the investigation and detection of criminal offenses and the prosecution of criminal offenses. So it's kind of like the rules of the game for what the cops can do and can't do to investigate crime, and then the rules of the game for how criminal trials are conducted. It's different than evidence, because evidence is how evidence is presented, whereas criminal procedure is strictly limited to the criminal jurisdiction. Evidence is both criminal and civil. And criminal procedure is about, at the first instance, search and seizure, police questioning powers, police powers to require documents, the exclusion of illegally obtained evidence, the right to silence, the right to counsel, all the kind of stuff you see on television when police investigate crimes. And so the 2/3 of the class is learning the rules that govern how police can investigate crimes or not. That basically involves the Bill of Rights Act, which largely sets out the most important aspects of criminal procedure in New Zealand, the rights suspects have when they're arrested or suspected of criminal offending. And it also involves the Search and Surveillance Act and also parts of the Evidence Act. So like I said, about 2/3 of the class is devoted to that. The last third of the class is devoted to criminal adjudication. And criminal adjudication is essentially the rules that govern criminal trials. So your right to cross-examine witnesses, your right to be present and present a defense, jury selection, excessive pretrial publicity, change of venue, all that sort of stuff as well. So criminal procedure would be a class for one of two kinds of people. And again, it's a reasonable sized class. It's going to be taught in the second semester, and it's for one of two types of people. If you're just interested in taking one criminal justice or criminal related class out of interest, you might like this one because it does deal with a lot of stuff that you may be familiar with from movies and television or just sort of walking around knowledge of criminal justice matters. But if you definitely should take it if you're thinking about becoming a prosecutor or defense lawyer. So if you're getting into any kind of prosecution or defense work, what you learn in this class would be very, very important to how you would conduct cases on either side. So learning the rules of Crim Pro are important to anybody going into that business. So I think it would be good for either of those sorts of cohorts. Again, it's a 3-hour-a-week class, one 1-hour lecture, one 2-hour lecture. It's a standard issue spotter exam, at the end with an opinion sort of piece of written work component as part of it. Nothing to buy except for the statutes which you can download, the Evidence Act, Search and Surveillance Act, Bill of Rights, Criminal Procedure Act. The rest of the materials are produced by me in-house, involving all sorts of criminal investigation and adjudication cases from the courts up to and including the Supreme Court, which has been very much involved in the Crim Pro and evidence business lately. That's it. Any questions about any of that?
I have a question for you.
Yeah.
We've just heard from Julian Long, who's going to be teaching civil procedure.
Yeah.
Can you say something about the relationship of his course to your criminal procedure and whether students should do one or the other?
Pretty much no relation at all. I mean, civil procedure, which I took in law school and really liked, is really about how the rules that govern the conduct of civil cases. And again, you want to distinguish it from evidence, because evidence is the rules that govern the presentation of proof in civil and criminal cases. So the way you present proof and the way you conduct trials, there is some overlap, but they can be two different things. So civil procedure is largely all the processes that take place in the context of civil litigation, largely governed by the high court rules and also by overlap with the Evidence Act. Whereas criminal procedure really is about things that happen before trial, which is the rules that govern how police actually investigate criminal offenses up to the point of arrest. And then the last third of the class, criminal adjudication, is the rules that govern the conduct of criminal trials once someone has been brought into the system. So the main difference is it focuses only on criminal jurisdiction, and its scope extends more broadly outside just the trial context to the actual investigative phase context, which involves many of the things you would have heard of: search and seizure, police questioning, the right to silence, the right to a lawyer, that sort of thing.
So competition law first. Okay, the course for competition law is a standard sort of competition law course, or what the Americans would call antitrust course. And we focus on the Commerce Act, in particular really sort of parts 2 and 3. So the sort of conduct that sort of gets caught up is mergers and acquisitions that will lessen competition. So there's been quite a lot of media coverage this week about the Fairfax NZ-NME merger as well, for instance. The idea that the two newspaper groups in New Zealand with two major websites, news websites, would potentially merge together, eliminate competition. The question is, when does competition get eliminated and when does that breach the Act? And also, in this particular case, is there some sort of public benefit that may sort of justify this particular merger going ahead as well? So this will be litigated in the High Court this week. So obviously those sort of mergers and acquisitions are one of the key things. Also what's important is lots of sorts of conduct that can breach the Act. So price fixing, various other sorts of arrangements, joint ventures. Sometimes these can lessen competition between competitors, reducing sort of consumer welfare, the benefits to consumers that they expect from competition. Also sort of taking advantage of market power. You have large corporations that have a sort of a dominant position in a market, and by engaging in a variety of competition or anti-competitive acts, they be able to eliminate sort of particular competitors, smaller firms from the market as well. Okay, so it's a standard sort of competition law antitrust course. The logic behind the course and the structure and the thinking is quite similar. Our act is based on Australian law, but also the stuff, the law in the UK and the US and the EU, all quite similar, and all based on a lot of similar thinking and understanding. Competition law, we tend to sort of take a sort of a more of a policy perspective to that as well, really thinking about some of the economics and the arguments behind particular provisions and when they're likely to be breached as well. And it really reflects how sort of competition law cases are litigated in practice. My second topic, so please ask if you have any questions. My second topic is postgraduate sort of courses for undergraduate students. So every year we open up one or two or several sort of the postgraduate courses for undergraduate students. This tends to be sort of only final year undergraduate students who are allowed to do the postgraduate courses. And we generally choose courses that there isn't an equivalent at the undergraduate level, and that we think students may have some particular interest in doing that particular course. So the postgraduate courses, sometimes they're taught a little bit differently from the undergraduate courses. A lot of our courses are taught on an intensive basis, and they may be taught sort of for 5 days for 6 or 7 hours a day. So the actual lecture time is jammed into a short period of time. Some of the courses are taught sort of throughout the semester. Typically, if they're taught throughout the semester, they're taught 1 day a week, so between sort of 5 and 8 p.m. So quite a different sort of timetable from the undergraduate courses. The assessment is also quite different as well. Whereas your typical undergraduate course, there'd be an assignment and a final exam, okay, particularly for the electives. When it comes to the postgraduate courses, there are no exams. The assessment is all based on sort of research papers, or almost entirely based on research papers. And so we have courses that are 15 points and 30-point courses. So the 15-point courses typically involve writing approximately 6,500 word sort of research essay. The 30-point courses involve writing a 12,500 word research essay. So it's a different set of skills. So possibly if you're not enrolled in a sort of an honours dissertation or honours seminar, you may not get an opportunity to write a long piece of work or engage in a piece of detailed research work. So maybe there's some sort of interest in you doing so as well. You've got some particular topic you wish to explore. What else we've got? Yeah, so I guess as far as sort of who would be suitable for doing these particular courses, we tend to sort of set the entry criteria so that only students in their final year, so having completed part 3, are able to do the postgraduate courses as part of their undergraduate degree. There also tends to be sort of a GPA cutoff of 5 as well, so you need to be performing reasonably well in parts 2 and 3 before we will allow you to do the postgraduate courses. Is it difficult? No. Students who tend to do it tend to sort of perform just as well, if not better, than they do in their undergraduate courses as well. So by the time, because we're only focusing on students in their last year, people have had the experience of writing and research, and so they have the skills necessary to perform quite well in these particular courses. So there'll be a list that's sort of posted up fairly shortly about the courses. So a number of our courses are taught, particularly the intensives, they're taught by sort of visitors. So people who are not necessarily based at the University of Auckland. So probably about a third of our course are taught by visitors, people who come from other parts of the world. People from Oxford, all sorts of places that sort of you may be interested in studying. So we have quite a range of sort of international sort of people who teach on the particular program as well. So I don't know if it's any particular use or interest, but I'll read you the list of topics we've got. We've identified that may be of interest to you as well.
And they have copies of the list, which is there on the table.
Okay, there's already a list, so I won't read it. There's one or two sort of typos in it, but it's pretty accurate as well. Yeah, so that's postgraduate courses for undergraduate students. If you've got any questions, please feel free to ask me or come talk to me in my office anytime.
Kia ora everybody, I'm Caroline Foster, married with 2 children, no pets, which is a subject of great dispute in our household, and I'm working on the pets side of things. So I'm talking with you about 2 courses today. The first of those is public international law. So that is the law between countries, if you like, between states. And this 20-point course, which runs in the first semester, is an introduction to how international law works and to all of the most important and basic aspects of that legal system, we can call it. So if you were going to learn about any legal system, you'd learn about what the sources of law were. We start with that. You need to know about who the actors in your legal system are. Primarily here it's states or countries. We look at what we call the subjects of international law, and we study the topic of personality in international law. And then we look at the powers of these states, often in the form of the exercise of jurisdiction, and then we look at what happens if they break international law. We look at what's known as responsibility in international law. Okay, so these are the core elements of any international law course that you would study in any country. We then go on and we start to get a little bit more into this kind of compliance side of things and dispute settlement, and we look at what international courts and tribunals do. And then we get into, having learnt the basic structural mechanisms of how international law works, the substantive area of the use of force in international law. So we start with collective security, we look at the way that the UN system operates, and then we look at some of the current quite high-profile examples of international conflict and war, with particular reference to what has happened in Iraq over the last decade, a little more than that now, Afghanistan, Syria, and if there's time we also look at Ukraine and the Russian presence in Ukraine. So this isn't just for people who want to go and practice international law. It's important that as many of the graduates of our law degrees as possible have a good understanding of how international law works. It's so much a part of the world that we live in now, but it is an especially helpful course if you did want to go and look at how you might engage in this kind of area in practice. Working for government would be the main way to do that. In my case, I worked for Foreign Affairs and Trade for a little bit under a decade after I got my law degrees. And then there are international organisations and non-governmental organisations, and there's a little bit of private practice in these areas as well. It's also a great area for postgraduate work, if that is something that you think you might be attracted to. Lots of great and interesting and important topics for the world to address. Perhaps if I talk about advanced and then just if there's a moment to see if there's any questions. So advanced international law is running in the second semester of next year. You have to have done international law before you do advanced international law. We welcome international students in this course, but just a little caveat that you need a reasonably high level of English conversational ability for the advanced course. There's quite a lot of class discussion. The aim of the advanced course is to extend people's knowledge and skills in international law, both on the conceptual side, thinking about concepts like sovereignty, and in terms of policy-based reasoning and analysis of the type that you would discover in practice. So the material is quite advanced. It's designed to be a more challenging course, and there's a real emphasis on student commitment to readings, participation in class. And then what students will come away with will be, an enhanced level of skills in this field. It could be useful for seeking employment, could be useful for further research and study. It'll also introduce you to intersections between subfields of international law. So you have a chance to get a bit more of an overview of the fact that out there in the world of international law, it's not all about fighting in bombs or even peace for that matter, but we have the whole field of trade law, of investment law, of environmental law, of law of the sea, as my colleague Vincent is going to discuss with you, and of human rights law. And also that international law at the end of the day isn't actually all about states and governments. Increasingly, the role of private actors and companies is taking a step to the fore. So we'll look at how business fits into international law these days. And then that's all anchored in concrete studies. So we take specific case studies like tourism in Antarctica, climate change and investment in renewable energy projects, trade bans on harmful products like cigarettes, exploitation of bioorganisms and such like. So it's a more demanding course and taught in a slightly different format. Have I time to take a question or two?
Yeah, and in fact, could you say something about the assessment of both courses?
Yes, of course I can. So thank you for that.
Can I just interrupt and say, if you look at the assessment spreadsheet, you'll see that international law appears for both first semester and second semester. That's no longer correct. So international is first semester only. What is missing from here for the second semester is advanced international, because it's only recently entered the picture, but the timetable is correct and has the correct courses as they will be offered next year.
Yes, so the assessment for international law, which is in the first semester, is a test which is an hour and is likely to be an essay question on which you then get feedback, and an examination which would be 2 hours. Okay. The assessment for the advanced international law course is a little different, reflecting the greater emphasis on participation, although we also expect that in international law. It includes a participation component expected to be probably of 10%, no test, but some written assignments which will be fairly short and probably worth something like 10% of the mark, and then an examination which will be worth the remainder of the mark, something like 80-70%. Yeah.
Thank you.
Hey, questions? Yeah.
The handout says that advanced international law is 20 points.
Yes.
It's only 10 this year. Is it 20 next year?
That's correct. Yep. Yep.
So the 30 points, for international law, the 30 points it's stage 2 in global politics and human rights, so we have to have done that as well.
No, that's an alternative, and that's for students who are doing the Global Studies program.
I'll catch up with you with that later. I'm throwing my head. Yeah, they're both 20 points. So they're both 4 contact hours a week. It'll be taught in 2 groups of 2 hours. So you come to class twice, but you stay for 2 hours each time. And me too, I do that too.
Well, last in the queue, but hopefully not least. Good afternoon, everybody. So my name is Vincent Kuliati-Barnes. I'm a newly appointed associate professor here at the law school, and next year I will offer an elective on the law of the sea. So what is the law of the sea? Well, the law of the sea basically is the public law of the oceans. In fact, it's more than that. It is an international public law of the oceans. So in a sense, it is a subcategory, a specialized category of public international law. So what we will investigate in the course is, well, what are the main rules that nations have designed among themselves for the peaceful public regulation of the principal uses of the oceans, such as navigation. I'm sure you've all heard of the terms high seas or perhaps territorial sea. Well, we will determine what these terms, what these notions encompass from a legal perspective. Access to resources is also a major concern of the law of the sea, not just fisheries, but mineral resources and other forms of biological resources, and so on and so forth. And in fact, we do have a treaty on all these questions, a very large treaty. In fact, it's called the United Nations Convention on the Law of the Sea, around which the course is built. So I think it's a fascinating topic. It's a fascinating course, I think, to take, not just because the oceans cover more than 70% of the planet, not just because more than 90% of world trade is carried by sea, but also because of the great variety of problems that we face in the law of the sea. I'm sure you've all heard of the problems in the South China Sea nowadays, in the South China Sea, yes. I'm sure you've all heard of piracy off the coast of Africa, off the coast of Southeast Asia. I'm sure you've all heard of instances of a nation arresting and boarding the ship of another nation to control the nature of the cargo aboard. Well, all these questions are determined in law by a branch of science called the law of the sea. So I think at the end of the day, what the course aims to do is to give you an understanding of these main principles governing the law of the sea, the use of the oceans, but also the reasons, the motivations behind those rules, and we will look at them in their historical, in their international, but also in their regional perspective. I think the course could be a great course to take for those who intend to pursue a career perhaps in diplomacy, oceans management, maritime affairs, but much more broadly for all those who have an interest in the oceans. And the assessment, there will be two pieces of assessment. One is a research essay, and the other piece of assessment is a final exam in class. So I think that sums it up.
Just
Thank
for
you.
clarification, could you talk about the relationship of your course to maritime law, or the lack of a relationship?
My course really focuses on the public aspect of the use of the oceans, whereas maritime law is, well, basically more commercial law, so would be classified more as private law. My course is really a subset of public international law. So we won't deal with things like charter parties and these. This is really for maritime law. Is there any questions? No? Thank you. Thank you very much.
There. So you'll see that we skipped over Joanna Manning, healthcare law. Jo can't be here, but she's asked me to just make a few points on her behalf, so I'll just speak to that course briefly. Healthcare law is co-taught by Professor Joanna Manning, whom some of you will know from talks, all of you will probably know from talks, and Professor Ron Patterson, who was for a decade or so the Health and Disability Commissioner, the second Health and Disability Commissioner in New Zealand. So they share the teaching of the course, and the course is looking at a variety of issues, different areas of the law that arise within the health sector. So the topics that Jo and Ron propose to cover next year, and the course will be in the first semester, and it's on Tuesday mornings 9 till 11 and Friday 1 till 2, 3 hours a week. These topics: firstly, the Cartwright Inquiry, which was a major health scandal in New Zealand and which made recommendations that were later adopted and made into law in New Zealand, such as the Code of Rights, which was recommended by the report after the Cartwright Inquiry. An introduction to medical ethics and some case studies. Other forms of accountability, such as the disciplinary process relating to health professionals. Some specific issues in medical negligence and ACC treatment injury. A key topic in the course is consent to medical treatment. What does the law require for a valid, legally enforceable consent? What is competence and what is meant by informed consent? Following on from that, the teachers look at the circumstances when it is lawful for a health professional to provide treatment to a patient who is unable to consent, who is not competent, including medical treatment provided to young children and adolescents. There's some consideration of rationing of resources in the healthcare context, which is an ongoing problem. So some of the legal issues associated with decisions about who gets treatment as a priority and what the law has to say about that issue of rationing. And the last topic in the course is to do with the court's contribution to assisted dying as a law reform issue. So the Seymour bill, drawn out of the ballot, will come before the House. the circumstances in which it's lawful to withdraw life-prolonging treatment, such as removing ventilators at the end of life, and the associated issues. The course is assessed by way of a compulsory test, a 30-minute test which contributes 20% of the final grade, and then an open book exam at the end of the semester for the other 80%. Just coming back to where we started, those generic things, there's just one point I want to make in respect of the honours seminars, or in particular the seminar that Tressa Dunworth will be offering next year on international law. And that is that Caroline's international law course, which will be offered in the first semester, is a co-requisite. So if you are a prospective honours student and you think that the honours international law seminar is the one that you might want to take next year, then just be aware that you need to be concurrently enrolled in the first semester in international law, unless you've already passed that course. Other than that, I have nothing else to contribute, but do you have any questions or comments? Yes?
Could you say anything about the community law internship?
Yes, so there are three possibilities for involvement with community organisations. The least of them is a community law placement, where you spend 40 hours with a community organisation and you write a little reflective report on the experience. And for those of you who would be enrolled under Law 499, that can substitute for one of the opinions that you otherwise would write. But aside from that, there's no academic credit associated with that experience. The community law project involves spending a couple of weeks or equivalent, so a minimum of 75 hours with an approved community organisation, and writing a 5,000 word report, because this is a 10-point course. So there is 10 points of academic credit available for the community project. The community law internship is just a step up from that. It carries 20 points, it involves a 10,000 word report, and it involves 150 hours with a community organisation. Now, those community organisations that you might be placed with, and on which, or your experience of which you write a report about, are typically in New Zealand, but they don't have to be. So sometimes students might be overseas, let's say over the summer, and make arrangements to work with some community organisation, reflect on that experience, and attract credit as a result. So 20 points for the internship, 10 points for the project, 0 points but credit for an opinion towards Law 499 in respect of the lesser community placements. Enough information?
Was that on the website it says the community law internship is offered in summer school?
The community law internship, the community law project, and the community law placements can be organised at any time that you can find a community organisation that's willing to accommodate you, give you a worthwhile experience. Yeah. So potentially all three are available in summer school or first semester and or second semester. Anything else of a general nature? Okay, well then we'll draw it to a close, and thank you for your attendance and your patience throughout. Something of a marathon effort, endurance demonstrated, so thanks very much.